give you
You're
your
on
lawful
private
order.
property. Step out of the
This
car.
is not a traffic stop,
Step out of the car.
and I have not broken a law.
Well, I'll tell you what, you're under arrest, so get out of the car.
Get out of the car.
The day after this false arrest, I filed a complaint with the Sheriff's Department for being arrested without probable cause and unnecessary escalation. I also put the video of the stop up on YouTube. The sheriff responded back a couple weeks later and agreed there were civil rights violations and a lack of de-escalation by the first two officers, and as a consequence, they were going to get some training. I responded back that I was not satisfied with just some training and wanted to escalate the complaint. Around this same time, the video that I uploaded of the stop starts to go viral, which generates complaint calls to the sheriff. Thank you very much, by the way. I also filed a Freedom of Information request for the body cam from the incident and anything else related to me. And here's where things start to go south. 1 week after replying to me that there were civil rights violations, Sheriff John Johnson reversed his decision and with no new evidence, decided to file charges on me. So now, instead of responding back to me, Lieutenant Johnson emails Captain Tom Bolts telling him that not only were the first two officers justified, but they should have used more force on me during the stop. Also, that they're going to reopen the investigation on me. As a result, they end up filing 7 charges a month later and issuing a warrant. Lieutenant Johnson does this without letting me know and just leaves me hanging on the complaint. The charges they ended up filing were resisting arrest, failure to comply with an officer, failure to ID, 2 counts of disorderly conduct, and 2 counts of threatening or intimidating. Captain Bolts and Lieutenant Johnson then emailed the entire department declaring me a sovereign citizen and telling everyone to be on the lookout. They also open up a terrorist investigation and request a threat assessment to be done on me. That's right. If I wasn't on a terrorist watch list before, I definitely am now. All for a little contempt of cop when they came up violating my rights. At this point, I still don't know I have warrants out. So when I go to pick up the Freedom of Information request, I end up getting arrested. Fortunately, I got to see the judge that day and got released on a PR bond, and due to the nature of the charges, was defending myself pro se. I had no intent of taking any deals. I knew I had the evidence to show the charges were false. One of the first things I did was file a motion to suppress evidence from the stop regarding 3 of the 7 charges for lack of probable cause to arrest. The judge ordered an evidentiary hearing on the motion to suppress, where the state doesn't call any witnesses, they only use the police report, and don't want to use the body cam because they contradict each other. The state ends up losing, and 3 charges are dismissed. The judge rules I was arrested without probable cause, and also that he doubted there was reasonable suspicion to detain. At this point, I was still going to trial on the other 4 charges, the 2 for threatening and intimidating, and the 2 for disorderly conduct. The judge ordered the prosecutor to arrange for depositions before the trial, which they did not do. On the day of trial, when the judge hears this, he stops the trial and orders us into a back room to do depositions right there. They end up taking the rest of the day, and the trial got rescheduled 2 weeks. During the 2-week delay, the state took the opportunity to appeal the decision for the dismissal of the 3 charges, claiming they were not allowed to call any witnesses, even though they simply chose not to call any. Either way, it ends up going to the appeals court, which delays another 4 months, and they end up just ordering a new evidentiary hearing, where I get the same result, and the state becomes a 2-time loser, and the charges are still dismissed. I guess the good thing is the delay also gave me time to go through all the information I got from the Freedom of Information request, and that's where I ended up finding all the evidence of the retaliation and being labeled a terrorist. So with the evidence of the retaliation, I filed a second motion to dismiss the remaining 4 charges for First Amendment retaliation. This is based off of Arizona's Anti-SLAPP statute, ARS 12-751. I was claiming they retaliated against me for filing a complaint and putting the YouTube video up of the false arrest. SLAPP stands for Strategic Lawsuit Against Public Participation. It's used to protect people against lawsuits or criminal charges that are filed in retaliation for exercising the First Amendment. Anti-SLAPP motion can be filed at the beginning of a case and is meant to save people from having to go through the burden of filing a whole motion to dismiss or even go through the discovery process just to prove that they were being retaliated against. In my case, the judge ended up accepting the motion and ordering the state to respond and setting an expedited evidentiary hearing. So, for whatever reason, probably because they kept losing, the state decides to change prosecutors from Cynthia Giltner to Kevin Crow. At the evidentiary hearing, the state ends up only calling Sergeant Hooten and does not call Lieutenant Johnson or any of the alleged victims. After all that, I end up winning again, and the motion is granted. It's the first time an anti-SLAPP statute has been used to dismiss charges in a criminal case in any state. I'm not going to go over the whole thing because it's pretty long, but part of the judge's order reads, "The court finds that the defendant has established prima facie proof that the filed criminal complaint constituted a legal action against defendant and that such action appears to be substantially motivated by a desire to retaliate against the defendant for the lawful exercise of his constitutional right to pursue a personal complaint against Yavapai County Sheriff's Office deputies." The state's response to defendant's motion to dismiss asserts that ARS 12-751 is not applicable as the charged offenses against defendant are not a lawful exercise of the right of petition, the right of speech, freedom of the press, the right to freely associate, or the right to peaceably assemble. While this assertion is correct, it is misplaced. The state does not address the salient issue of whether or not defendant's December 8th complaint against Yavapai County Sheriff's Office deputies was a lawful exercise of the right of petition. Additionally, the state's response does not address any of the factors set forth in ARS Section 12-751B1. At the evidentiary hearing, the state called Sergeant Hooten as its sole witness. Sergeant Hooten provided detailed testimony regarding his investigation of the defendant and the evidence gathered in support of the filed criminal charges. Sergeant Hooten was unable to testify as to Lieutenant Johnson's motivations for ordering the new investigation. Sergeant Hooten also testified that he was instructed by his supervising officer, ostensibly Lieutenant Johnson, as to what charges were to be filed against the defendant. The court finds that Sergeant Hooten's testimony sufficiently articulated facts that would justify, by clearly established law, the legal action taken. Specifically, the state's filing of the criminal complaint, the first prong of ARS 12-751B1, has been satisfied. However, the state failed to sufficiently rebut defendant's prima facie showing that the initiated legal action was done for the purpose of retaliating against the defendant's exercise of a constitutional right. Lieutenant Johnson initiated the new investigation and ultimately directed what specific charges were to be filed against defendant. Further, Lieutenant Johnson had direct knowledge that defendant had filed a complaint against the sheriff's office deputies and was aware of the defendant's intent to escalate the complaint. It is important to note that Sergeant Hooten failed to provide evidence relating to whether the Yavapai County Sheriff's Office had a consistent practice of initiating new or continuing criminal investigations against other similarly situated persons who had not lawfully exercised their constitutional rights. Therefore, the court finds that the factors in the second prong of ARS 12-751B1 have not been met, and this same section mandates that the court shall grant the motion unless the state sufficiently rebuts the defendant's prima facie showing. It is hereby ordered granting the defendant's motion to dismiss or quash. It is further ordered dismissing counts 1, 2, 3, and 4 of the complaint. So there it is. After more than a year of dealing with this nightmare, all charges have been dismissed. As a result of all this, I've now filed 2 federal lawsuits. One against the Campground, Thousand Trails, and the employees involved, and one against the Sheriff's Department, the county, and the officers individually. There are a total of 15 defendants and 21 claims. In both cases, the defendants have filed a 12B motion to dismiss for failure to state a claim, and in the 1983 case, they also claim improper service and assert qualified immunity. There's also been an amicus brief filed by Arizona's First Amendment Clinic focusing on challenging qualified immunity. At this point, all responses have been submitted, and we are waiting for the court to rule on the motions, which could be any day now. Depending on the rulings, we are either going to start discovery or head to the appeals court. I'll keep you posted. For those wondering about the dogs, Ringo and his Great Pyrenees buddies are doing well. Please consider leaving a comment or sharing this video. It helps the channel out a lot. I really appreciate everyone's support. Thanks for watching.